This is part 21, and in this part, as I had told you, we shall come back to section 6 in order to deal with further part of the definition of the check with which we had not dealt. Now, if you refresh your memory, section 6 defines check as follows. It says, a check is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on demand. That is the definition of the check with which we had dealt. And further part of the section says, and it includes the it includes the electronic image of a truncated check and a check in the electronic form. This was an amendment which was brought about by the Act of 55 of 2002, which came into effect 6th of February 2003. So now the definition of the check that you have to read along with a check is a bill of exchange drawn on a specified banker not expressed to be payable otherwise than on demand, and it includes the electronic image of truncated check and a check in the electronic form. To understand this, we have to go through the explanation. And explanation 1 says, for the purposes of this section, the expression a check in the electronic form means a check which contains the exact mirror image of a paper check and is generated, written and signed in a secure system, ensuring the minimum safety standards with the use of digital signature with or without biometric signature and a symmetric crypto system. So that is what is meant by a check in the electronic form as far as small a is concerned. And small b says a truncated check means a check which is truncated during the course of a clearing cycle, either by the clearing house or by the bank, whether paying or receiving payment immediately on generation of an electronic image for transmission, substituting the further physical movement of the check in writing. And the explanation 2 says, for the purposes of this section, the expression clearinghouse means the clearinghouse managed by the Reserve Bank of India or a clearinghouse recognized as such by Reserve Bank of India. Now, with this in view, Reserve Bank of India has introduced CTS 2010, namely check truncation system, and that has come into force, or as far as some part like of the territory of India like Delhi and other is concerned. But now Reserve Bank had made it compulsory that this system, check truncation system, shall be operative throughout the territory of India from 1st of January. But as present, that has been postponed, and now this shall be applicable throughout the territory of India from 1st of April. Now, this check truncation system is to stop the flow of physical check. And what is done? Electronic image of check is transmitted to the drawee branch by the clearing house. So there is bound to be efficiency. As far as possible, this is to overcome the offenses that are likely to take place, and hence this has been decided, namely this is what is known as check truncation system. And then in order to understand this during course of time, when this will come into operation, everybody will come to know accordingly. But in order to understand the definition of check along with definition of the check with which you have dealt in the past, now we have to understand that it includes the electronic image of truncated check, that is one part, and a check in the electronic form. So that we have to understand for the purpose of understanding the same. With this now, this is a time during course of when we were discussing with many provisions, we came across one section, namely section 64. And while dealing with section 64, I had told you, as far as subclause 2 is concerned, what we shall be doing, we shall have reference. So in order to understand subclause 2, which deals with presentment for payment, now the time for you to refresh your memory right from section 61 up to section 77 dealing with presentment of the negotiable instrument. It may be presented for the purpose of acceptance, or it may be presented for the purpose of payment. Presentment for acceptance is the provision that is only applicable as far as the bill of exchange is concerned, but presentment for payment is applicable as far as promissory note, bill of exchange or check is concerned. And when we were discussing section 64, the time for me to have reference to subclause 2 as far as section 64 is concerned, which says, notwithstanding anything contained in section 6, where an electronic image of a truncated check is presented for payment, the drawee bank is entitled to demand any further information regarding the truncated check from the bank holding the truncated check in case of any reasonable suspicion about the genuineness of the apparent tenor of instrument, and if the suspicion is that of any fraud, forgery, tampering or destruction of the instrument, it is entitled to further demand the presentment of truncated check itself for verification. So that can be demanded as far as subclause 2 of section 64 is concerned. But what is proviso? Provided that the truncated check so demanded by the drawing bank shall be retained by it if the payment is made accordingly. So this is, this is required to be done as far as the payment with respect to the truncated check is concerned, of which mention is made as far as subclause 2 of section 64, with which we had dealt in the past, barring only subclause 2. With this now, the time for me to draw your attention to when we were talking about the payment is required to be carried out right from
section 78 up to the 78 up to 81. This is the time for me to draw your attention to section 81, subclause 2 and subclause 3. Delivery of instrument on payment or indemnity in case of loss. So, and subclause 2 says, where the check is an electronic image of truncated check, even after the payment, the banker who received the payment shall be entitled to retain the truncated check. Generally, the practice that is required to be followed is that you carry out the payment and you return the negotiable instrument. If the negotiable instrument, the holder takes negotiable instrument to the maker will pay the amount and will take the negotiable instrument. It is the duty of the holder to return it to the maker. Same is the case as far as the bill of exchange is concerned, that is required to be returned to the person who has carried out the payment. But here, subclause 2 says, where the check is an electronic image of a truncated check, even after the payment, the banker who received the payment shall be entitled to retain the truncated check. And subclause 3 says, a certificate issued on the foot of the printout of the electronic image of a truncated check by the banker who paid the instrument shall be prima facie proof of such payment. And then, as far as the payment, proof of the payment is concerned, whether the payment was carried out or not, a certificate issued on the foot of the printout of the electronic image of a truncated check by the banker who paid the instrument shall be prima facie proof of such payment.
So that is section 80. As far as when we talk about delivery of instrument on payment, these are the provisions which are applicable as far as truncated check is concerned, with which we have to deal as far as subclause 2 and subclause 3 of section 81 of this Negotiable Instrument Act is concerned. With this now, when we proceed to the next chapter, namely when the parties are discharged from liability, right from section 82 onwards up to 90, the time for me to draw your attention to section 89 and then refer to subclause 2 and subclause 3. Heading of section is payment of instrument on which alteration is not apparent. Subclause 2 says, where the check is in an electronic image of truncated check, any difference in apparent tenor of such electronic image and the truncated check shall be a material alteration. So what shall be a material alteration with which we have dealt? And now as far as the truncated check is concerned, it says where the check is an electronic image of truncated check, any difference in apparent tenor of such electronic image and the truncated check shall be a material alteration, and it shall be the duty of the bank or the clearing house, as the case may be, to ensure the exactness of the apparent tenor of electronic image of truncated check while truncating and transmitting the image. So that is as far as subclause 2 is concerned. And subclause 3 says any bank or a clearing house which receives a transmitted electronic image of truncated check shall verify from the party who transmitted the image to it that the image so transmitted to it received by it is exactly the same. So this is as far as the alteration is concerned, for which as I told you, you have to refer to two sections, namely subclause 2 and subclause 3 as far as section 89 is concerned. That I had told you while we were dealing with this section at the time we dealt with this particular chapter. With this now, the time for me to draw your attention that this is the time for us to deal with now checks in general, and for the purpose of understanding this, yes, we have to deal with one chapter, and that it deals with criminal liability, because this is a civil enactment, and in case of civil law, the party, in order to establish the right, has to go to the court of law. There is no provision of going to the criminal court. But then as far as checks are concerned, there was an amendment because of which now we shall be dealing right from section 138 up to section 147, which deals with criminal liability of as far as that makes mention of penalties in case of dishonor of certain checks, with which we shall be dealing. That was amendment to the Negotiable Instrument Act, with which we shall be dealing. But before that, this is the time for me to draw your attention to one chapter, and that is chapter 14, dealing with cross checks. And to understand this now, we have to start right from discussing right from section 123 up to section 131A of the Negotiable Instrument Act, and the heading of it is of cross checks. And then the first section, section 123, say check cross generally. Now it says where a check bears across its face an addition of the words added company or any abbreviation thereof between two parallel transverse lines, or of two parallel transverse lines simply, either with or without the words not negotiable, that addition shall be deemed a crossing, and a check shall be deemed to be crossed generally. When the check is issued, there is a provision. If it is a bearer check, the person to whom the check is issued or the person to whom the check is delivered may directly go to the bank and get payment of the check across the counter. So check may be payable to the bearer. In case when you scratch the words bearer on the check, that is what is known as an ordered check. And in case of ordered check, the payment must be as per the order, and hence the practice that is followed by the bankers is that when it is not a bearer check, payment is never at the counter, it is credited to the account of the customer. A bearer instrument may be a check with which we are dealing at present may be negotiated by mere delivery. So if A draws a bearer check in favor of Mr. B, B can by all means pass a delivery to C, C to Mr. D and D to Mr. E accordingly. And the bearer can go to the bank and he can claim payment with respect to the check. If it is an order instrument, as we have dealt with endorsement, if you remember, to be correlated with negotiation, there we have learned, in case when it is an order instrument, there must be an endorsement and then delivery of the same instrument. And a signature on the back of the instrument also constitutes valid endorsement, and what is written above the signature determines the nature or different. There are various kinds of endorsement with which you are dealt during course when we had dealt with this particular part of the Negotiable Instrument Act dealing with endorsement and delivery of a negotiable instrument. So now if the person A has drawn a check in favor of Mr. B, A from the point of view of security may add or he may have two parallel transverse line across the check. Is it only the drawer? No. I mean, A can give bearer check to Mr. B, Mr. B can deliver it to Mr. C, and C can also by all means put two parallel transverse lines across the check. What is the effect of it? This is what is known as crossing. If you merely put two parallel transverse lines, maybe with the words and company or any abbreviation thereof, yes, this is what is known as general crossing of the check. Because of the crossing of the check, a bearer instrument becomes an order instrument, and when it is required to be negotiated, there must be an endorsement and delivery of the same. This type of crossing is what is known as general crossing. And then the practice that is followed is that the person who wants to get payment with respect to the check which is crossed will have to go to his bank where he is having an account, and he will have to deposit that check into that bank. That bank is what is known as collecting banker, and the amount will be, that check will be sent by the collecting banker to the paying banker, and naturally now there is bound to be, this physical movement of check will be strong, will be stopped as far as the system, check truncation system of 2010, with that I told you, but otherwise today also this practice has been followed, and then the banker, paying banker, will get it confirmed regarding what? Regarding sufficiency of the amount, whether the signature tallies with that of the specimen signature of the customer or not, namely the drawer, and then when it is clear, that account will be credited to the person, namely or by the into the account of the collecting banker accordingly. At times it may happen that there may be a name of the bank may be written between two parallel transverse lines, and section 124 says where a check bears across its face an addition of the name of the banker, either with or without the words not negotiable, and that addition shall be deemed a crossing, and the check shall be deemed to be crossed specially and to be crossed to that banker. So if name of the banker is written between two parallel transverse lines, this is what is known as spatial crossing. And what is the effect of it? The effect of it is that this such a check shall be deposited only with the bank whose name is written between two parallel transverse lines. In other words, collecting banker can only be that banker whose name is written between two parallel transverse lines, otherwise not. This is what is known as spatial crossing. Section 125 says crossing after issue, and it says where a check is uncrossed, the holder may cross it generally or specially. So holder by all means, and then if you remember, I had made mention when we were discussing regarding material alteration, this shall not be treated as material alteration because this is allowed, as we have dealt with section 20 as far as inchoate instrument, stamp instrument is concerned. Similarly, where a check is uncrossed, the holder may cross it generally or specially. Where check is crossed generally, the holder may cross it specially. And the further part says, where a check is crossed generally or specially, the holder may add words not negotiable. Now this is the time for me to draw your attention that when the words you receive a check and the words not negotiable are written between two parallel transverse lines which is drawn across the check, this is also the time for me to tell you that nowhere it has been mentioned where you should draw these two parallel transverse lines. And general practice that has been followed is that the two parallel transverse lines are always, this is from the point of view of security, which are always drawn at the left hand top corner of the check. And then when the words not negotiable are written and when you receive such a check, you must be aware of the fact that you cannot become holder in due course. In other words, you will be having same rights as those of the transferor, because when we dealt with the concept of holder in due course, we learned that this is an exception to the maxim nemo dat quod non habet. Title of the holder in due course becomes clear, but when you receive a check and if the words not negotiable are written between two parallel transverse lines, in that case, no, you cannot become a holder. You will have the title, no doubt about it. But which is the title that you will have, which you have derived it from the transferor? It cannot it cannot be more than that, or you can't become a holder in due course as we have dealt in the past. So this is one, additional security that can be taken, that well, the check will go to the person who is entitled, and the person, for example, if the check is received from a person whose title was defective, the person transferee, namely endorsee, title of the endorsee is that of endorser, and hence this is as far as the words not negotiable are concerned. Where a check is crossed specially, the banker to whom it is crossed may again cross it specially to another banker, his agent, for collection. So that can be done by the banker accordingly. When the words account payee are written between two parallel transverse lines, this is the direction which is given to the collecting banker and also to the paying banker, that this amount should be credited, to the account of the person whose name appears on the check. So in case of account pay check, though we say check is a negotiable instrument, naturally, as it is drawn in the name of some person and there are the words account pay are written between two parallel transverse lines, this check will be paid only to the person in whose favor it has been drawn. Now section 126, payment of check crossed generally. It says where a check is crossed generally, the banker on whom it is drawn shall pay it otherwise than to a banker. Payment of check crossed specially, it says, where a check is crossed specially, the banker on whom it is drawn shall not pay it otherwise than to the banker to whom it is crossed or his agent for collection. Section 127. Payment of check crossed specially more than once. And says, where a check is crossed specially to more than one banker except when crossed to an agent for the purpose of collection, the banker on whom it is drawn shall refuse payment thereof. Section 128. Payment in due course of cross check. It says, where the banker on whom a cross check is drawn has paid the same in due course, and this has got reference to what? Payment in due course as far as section 10 with which you are dealt. So it says, where the banker on whom cross check is drawn has paid the same in due course. The banker paying the check, and in a case the check has come to the hands of payee, the drawer thereof shall respectively be entitled to the same rights and be placed in the same position in all respects as they would respectively be entitled to and placed if the amount of the check had been paid to and received by the true owner thereof. So that is as far as section 128 is concerned, which deals with payment in due course of cross check. Section 129 deals with payment of cross check out of due course, and it says, any banker paying a check cross generally otherwise than to a banker, or a check cross specially otherwise than to the banker to whom the same is crossed, or his agent for collection being the banker, shall be liable to the true owner of the check for any loss he may sustain owing to the check having been so paid. So that is liability of the banker made clear as far as section 129 is concerned. Section 130 deals with the cases where check bearing not negotiable, to which I had drawn your attention. It says, a person taking a check cross generally or specially, bearing in either case the words not negotiable, shall not have and shall not be capable of giving a better title to the check than that which the person from whom he took it had. So when you receive such a check, this is sort of a warning given to you that you shall be entitled to have the rights as that of the person from whom you are receiving it, namely the rights of the transferor, rights of the endorser, when the words not negotiable are written between two parallel transverse lines. Section 131 deals with non-liability of banker receiving payment of check, and it says, a banker who has in good faith and without negligence received payment for a customer of a check crossed generally or specially to himself shall not, in case the title to the check proves defective, incur any liability to the true owner of the check by reason only of having received such payment. So this is non-liability of a banker receiving payment of check. And the explanation 1 to the section says, a banker receives payment of a cross check for a customer within the meaning of this section, notwithstanding that the credits his customer's accounts with the amount of the check before receiving payment thereof. And the explanation 2 says, it shall be the duty of the banker who receives payment based on an electronic image of truncated check held with him to verify the prima facie genuineness of the check to be truncated and any fraud, forgery or tampering apparent on the face of the instrument that can be verified with due diligence and ordinary care. With this, last section, namely section 131A, deals with application of chapter to drafts, and it says, the provisions of this chapter shall apply to any draft as defined in section 85A as if the draft were a check. We have dealt with this section 85A, and hence now if it is all provisions with which you have dealt will be applicable This is a draft drawn by one branch of a bank on another payable to order as far as section 85A is concerned. So application of this chapter, it says the provisions of this chapter shall apply to any draft as defined in section 85A. With this now, this is the time for me to draw your attention to, as we are going to proceed and deal with this dishonor of a check. The time for me to draw your attention that if the check is dishonored, payment which is required to be carried out, what is the liability of the banker? And there are some other, today we have dealt with some of the provisions as far as check, some of the provisions to which we had referred in the past when we started dealing with truncated check or electronic image of the check. We have referred to some of the parts as far as the with which we had not dealt in the past. Now the time that if check payment is required to be carried out by the banker. Now if that payment is not carried out by the banker, or if there is a refusal on the part of the banker, then what is the liability of the banker? And when the banker is justified in refusing payment with respect to the check with which we shall be dealing, and as soon as we finish with that part, we shall proceed to right from section 138 up to section 147, dealing with what? Provisions as for criminal liability in case of a dishonor of a check in the next part.